Welcome to our webinar on visitors. My name is Callum. I'm a solicitor in Field Seymour Parks' immigration and employment teams. When talking about visiting the UK in an immigration law context, it's good to clarify what exactly we mean by a visitor. Now, I've capitalised visitor on my slides to indicate that we're talking about the legal term rather than the general meaning of the word visitor. Now, a visitor might be someone who comes to the UK as a tourist, or to visit family or friends living in the UK. Alternatively, they might have come to the UK on a short-term basis to perform certain business activities, more on this later, or to engage in a short course of study. As you can see, the term visitor can cover quite a wide variety of people, all coming to the UK for very different reasons and in quite different circumstances. The key thing to remember for now is that, as a general rule, visitors can only come to the UK for up to 6 months at a time, though, as is often the case with rules, there are some niche exceptions. It is perhaps easier to answer the question, who is a visitor, by first answering the question, who is not a visitor? An individual is not a visitor if they have a British or Irish passport. Even if an Irish national had habitually resided in another country, for example France, for decades and was visiting the UK for a brief period, they would still not be a visitor in the legal sense. Additionally, someone who has a right of residence in the UK, for example on a skilled worker visa or under the EU settlement scheme, is also not a visitor. Some visitors to the UK will need to apply for a visitor visa before travelling, depending on their nationality. The Visa National List is a long list of various countries. Nationals of these countries are known as visa nationals and must apply for a visitor visa before they travel to the UK. The list includes China, India, Russia, South Africa and Turkey, to name just a few. This list is by no means set in stone and is subject to change on very little notice. For example, late in 2024, Colombia was added to the Visa National List. As a result, Colombian nationals who previously had not needed to apply for a visa before visiting the UK were suddenly and unexpectedly required to do so. There is a £115 application fee to apply for a standard visitor visa, and you'll usually need to book and attend an appointment at a visa application centre. It normally takes up to 3 weeks to get a decision from the date of that appointment, though the earliest that you can apply is 3 months before your planned date of travel to the UK. In reviewing your application, the Home Office will check that you are a genuine visitor, meaning that you intend to leave the UK at the end of your visit, and that you are not living or planning to live in the UK for extended periods through frequent or successive visits, or to otherwise make the UK your main home. They may also want to confirm that you will be able to support yourself financially during your trip, and that you will be able to afford your return journey when you leave the UK. With a standard visitor visa, you can stay in the UK for up to 6 months. This can be as a single visit of 6 months, or across multiple back and forth trips, though only up until the expiry date of the visa. Under a standard visitor visa, you could not, for example, make a 1-month trip to the UK every year for 6 years. There are other longer-term visitor visas with higher application fees and which last for longer periods of 2, 5 or 10 years. But most of these are still subject to the 6-month limit per visit. However, the genuine visitor requirement still applies, meaning that you cannot use a longer-term visa to essentially live in the UK through multiple 6-month visits. If you are a national of a country not listed on the Visa National List, then you do not need to apply for a visitor visa. However, you may need to apply for an electronic travel authorization, or ETA. Visitors from most non-EEA countries already need to apply for an ETA if they are planning to visit the UK, unless, of course, their country is on the Visa National List, in which case they should apply for a visitor visa. As for visitors from the EEA and associated territories, they will need to apply for an ETA in respect of any travel taking place from the 2nd of April 2025 onwards, with applications for this opening on the 5th of March 2025. The ETA application is much simpler than a visitor visa application and can be done entirely online without the need to book or attend an appointment. As part of the application, you will need to provide photographs of your passport and face, as well as various personal details. The application fee is currently £10, though this is set to rise to £16 shortly. It usually takes 3 working days to receive a decision, though we would recommend allowing more time than this if you're planning to visit the UK, just in case the Home Office have any follow-up queries on your application. Once you have your ETA, it is valid for up to 2 years, unless your passport expires sooner. The ETA is linked to whichever passport you used in the application. So, if you are a dual national, it is important to ensure that you bring the correct passport to the border. Although the ETA remains valid for up to 2 years, the same requirements apply as with visa nationals and visitor visas. You can only stay for up to 6 months at a time, and you must be a genuine visitor, meaning that you're not essentially living in the UK through multiple successive trips. As mentioned, many visitors to the UK will be coming for tourism or to see family or friends. Visitors can also come to the UK for a short course of study of up to 6 months, subject to various requirements. Some visitors to the UK may also be planning to do work of some kind during their visit, without going through the process of applying for a work visa. However, as a starting point, visitors are not allowed to do work, meaning that they cannot be employed in the UK, do work for any UK organisation or business, establish or run a business as a self-employed person, do a work placement or internship, directly sell anything to the public, or provide goods or services. That said, there are some exceptions to this general prohibition on work. Firstly, visitors can engage in certain specific activities defined in the immigration rules as general business activities. These include attending meetings, conferences, seminars and interviews, negotiating and signing deals and contracts, carrying out site visits and inspections, and gathering information for their employment outside the UK, including being briefed on the requirements of a UK-based customer. In 2024, these activities were also expanded to cover visitors working remotely for their overseas employer from within the UK, provided that this is not the primary purpose of their visit to the UK. Now, this leaves remote working in a bit of a grey area. Visitors coming to the UK for tourism or to visit family, for example, can do remote work for their overseas employer whilst in the UK, but they cannot come to the UK for the purpose of remote working. Then there are the intra-corporate activities, allowing visitors to engage in certain activities that might otherwise be seen as work, where they are employed by an overseas company in the same corporate group as the UK business that they're doing the work for. This includes advising, consulting with, providing training to, and sharing skills and knowledge with UK employees within the same corporate group as their overseas employer, where this relates to a specific internal project. In 2024, this was expanded to allow visitors to carry out these activities directly with clients, provided again that the activities are required for the delivery of a specific project or service by the UK business or branch. However, the exception in respect of working directly with clients will not apply where it relates to a project or service being delivered by the visitor's overseas employer. There are also exceptions relating to the manufacture and supply of goods to the UK, allowing an employee of an overseas company to visit the UK to install, dismantle, repair, service or advise on machinery, equipment, computer software or hardware, or train UK-based workers to provide these services themselves, provided that there is a contract of purchase, supply or lease between the overseas employer and a UK business. However, the overseas employer must be the manufacturer or supplier of the goods, or party to a contractual arrangement for after-sale services, which was agreed at the time of the sale or lease of the goods. This exception can be useful in enabling workers to provide installation or similar services without the need to get a visa, but its scope is rather limited, and we would recommend obtaining legal advice before seeking to rely on it. Permitted paid engagements allow experts and certain professionals in their field to visit the UK for up to a month in order to attend a particular event or engagement. This includes things like giving lectures and speeches or performing an activity relating to a profession in the sports or arts. Such engagements must be arranged beforehand, and the visitor must have evidence of a formal invitation. The engagement must also be completed within 30 days of the visitor's arrival, that they can then stay for the full 6 months afterwards. There are also various other exceptions relating to science and academic, legal services, and so on. If you have any questions about whether a certain activity is permitted as a visitor, please do get in touch. We've already considered in depth the routes and rules when visiting the UK, but I thought it would also be worth briefly touching on some factors to be conscious of when visiting other countries. The United States of America have had their Electronic System for Travel Authorization, or ESTA, in place for some time. This requires nationals of countries on the Visa Waiver Program list to submit an online application. In that sense, it works in much the same way as the new ETA scheme in the UK, though it only allows travel up to 90 days and has different restrictions on activities. The standard fee for an ESTA is $21 US. For those whose nation is not on the Visa Waiver Program list, they will need to apply for a visa, normally a B1 or B2 visa. The EU is introducing its own version of the ETA and ESTA, with the European Travel Information and Authorization System, or ETIAS. It is unclear when exactly ETIAS will come into force, but the current expectation is that it will open later in 2025, with a 6-month transition period, during which applying for an ETIAS travel authorization will be optional. However, once that transition period has ended, currently expected to be in early to mid-2026, all British citizens will be required to obtain an ETIAS travel authorization before entering the Schengen area. I should note that this does not apply to British citizens travelling to Ireland, who will still be allowed to visit, live and work in Ireland under the Common Travel Area arrangement. Currently, it is understood that the ETIAS fee will be €7, and that an ETIAS travel authorization will be valid for 3 years. Various other countries will also have in place certain visa or pre-registration requirements before arriving at the border. We would always recommend reviewing the relevant entry requirements well in advance of any planned travel or any expenditure on flights or accommodation. That's all from me for today. If you have any questions about visitor visas, the ETA, or permitted activities as a visitor to the UK, please feel free to get in touch with me at callum.defreitas at fsp-law.com. And, if you would like, you can also connect with me on LinkedIn using the QR code on screen. Thanks for watching.